Hello, my name is attorney Andrew Gill, and today I want to walk you through what we call the Revocable Trust Plan timeline to kind of give you an idea of who the players are in a revocable trust, what roles they hold, and at what point they become effective. So as you can see here, we have a chart with essentially three columns. Okay, we have you are alive and well. One category, you are alive but incapacitated and after your death. Remember that when we're doing estate planning, what we're really doing here is we're planning for all three of these aspects here. It's not just about when you die. It's about what happens when you're alive and well as what happens when you become incapacitated. Who's going to make those decisions for you? And then you can see on the left-hand side here, we have your medical decisions down at the bottom, children and pets care decisions, money and investment decisions. All right, so while you're alive and well, we'll start in the column to the left. You are the initial trustee. It could be you, or you could pick somebody else. For the most part, in a revocable trust, you, and if you're married, your spouse will serve as joint trustees. Okay? What that means is you have all control, all power. You can basically do whatever you want while you're alive and well. You can also have a general financial agent, someone you deal with, someone you work with, okay? Or that could just be you as well, depending on your unique situation. All right, now when we get down to the second box there, children and pets cares decisions. Obviously, it's just you, right? You're the trustee, you or your spouse, you and your spouse, whatever your unique situation is. Then again, your medical decisions, you're alive and well, you make those. Trust doesn't affect any of those important aspects. But where in that second box column there, I guess, is where the trust really comes into effect and where you should really think strongly about your planning. This is where you're alive but incapacitated, so you can no longer make your decisions. You may say, well, who determines if I am incapacitated? Is it a court? Is it the doctors? Is it my spouse? Who does it? Well, we define that. Your typical revocable trust will define what incapacity means. Now, incapacity could be defined as requiring the signature of a physician or two. Okay, oftentimes it's two. Or it could be, hey, you know what? I don't trust physicians. Someone could pay them off or convince them otherwise. Therefore, I want it to be a court of competent jurisdiction. Never really recommend the court of competent jurisdiction because our whole goal here is to keep you out of court and keep your matters private as opposed to exposing them to the public. Okay? And then the third sort of option there is you're incapacitated when it is deemed that you're incapacitated, meaning your family gets together and says, hey, he's incapacitated, he or she is incapacitated, so therefore let's trigger the incapacity provisions of the trust. So your incapacity would be your successor trustee. Okay, and we often refer to this exactly as it sounds, your incapacity trustee. So when you set up your trust, you say, look, me and my spouse, me and my significant other, whoever those trusts are going to be, whatever that relationship is for your unique situation. But what happens then is you pick somebody else. And not only that, you pick somebody else if that somebody else cannot serve as your successor trustee. So you think through, who do I want to make decisions for me? Who do I want to handle when I'm still alive? Not just who do I want to handle my stuff. And why this is important here is sometimes, when you think about that second little blue box in the column, the springing financial agent, you may have different children or different individuals who have different talents. You may want one individual making your financial decisions, but another individual making your health decisions. And that's not atypical. That happens quite a lot in families. Or you may want all your children to make those decisions. So you have your incapacity will be your successor trustee. Okay, who's going to be there when it's not you? Your springing, what springing means is that, hey, this financial agent only kicks in when the general financial agent, which again could be you or a specific entity or a specific person, when you are incapacitated. Okay? Now we get down to that middle box, who makes decisions for children's and pet care. Other parent can, or the guardian of minor children. You can also have what's called a pet caretaker. So what that means, again, we're appointing somebody to make decisions. Now, for the most part, most people become incapacitated when their children are adults. Okay? It's very rare that you find become incapacitated when your children are still minors, but it can happen. So if it can happen, we might as well prepare for it. And the same with a pet caretaker. You can determine who you want to take care of your pet, whether that's your dog or whether that's a horse that you love. And then finally, you get down to the bottom box, your medical decisions. Again, we've already covered this, but you're going to appoint a healthcare agent or a proxy to do that. It can be your spouse, but typically, if your spouse is alive, there's going to have your spouse do it. We're dealing more with the situation where you need somebody other than your spouse to make those decisions. And that's where you can, again, pick anybody you really want, as long as they're competent, as long as you trust them to make those decisions for you. All right, so if you're alive and well, it's all you. If you're alive but incapacitated, we get into the incapacity trustee. We get into the springing financial agent. We get into appointing a guardian for minor children or a guardian for your pet, okay, or your healthcare agent or proxy. After you die is the third box over here, and that's where most people think of estate plan. They think it's after your death. Your death successor trustee, which oftentimes is the same as your incapacity successor trustee, but this is the person who's going to be making those decisions about what happens to your stuff under the trust. Okay? You can also have a pour over will executor. Okay? This is only needed when you have funds or when you have assets that are not in the name of the trust. So what we call a pour over will means, you're most people think of a will, you say, I want Billy Bob, Susie, Johnny, Marnie, I want them to be receiving certain items from my estate, or you just divide up a quarter if you have 4, right? A pour over will is a little bit different because basically what you're saying is, hey, anything that's in my estate that's not in the name of the trust, I want it to be poured over into the trust. The trust will be the heir, not the individual children. Then you follow the terms of that trust. Okay, so that's what you do after your death. You have a successor trustee, and then we have this sort of belt and suspenders pour over will. Now, children and pets, the other parent if they're still alive, or you can appoint a guardian for minor children. Okay, and the same with the pet caretaker. Not very different from incapacity at all, really. Now, your medical decisions, obviously you're gone, so we don't really care about that. But when you look at this, remember, estate planning is for these 3 areas. You're alive and well. So what benefit do you get from there? You get the benefit of knowing that should you become incapacitated, should you pass away, your assets and your family, loved ones, whoever it is which you wish to take care of, your pets, are taken care of. If you're incapacitated, we've provided a way for you to be taking care of yourself and to make sure your loved ones, your assets, your stuff, everything is taken care of as well. And who's going to make those medical decisions? We avoid having to go to court, which would be the alternative if we did not have these provisions. Then after your death, we're providing for a smooth transition from your ownership now to ownership by either the trust or the individuals with whom you want to bestow these items upon. So this is sort of the matrix of a revocable trust plan timeline. All right, so now let's talk about what if I don't select every fiduciary listed. So remember we had all those boxes, right? And this is what's critical. If someone needs authority to act on your behalf, the court can appoint somebody. Okay, so it's not like it doesn't happen. It's just now you're in court. You're paying an attorney, or your loved ones are showing up at court, walking through the maze of probate court. So depending on the exact need, the title of this person and the type of court case will vary. Sometimes it can be a guardianship, sometimes it can be a conservatorship. It can be very specific. Sometimes somebody can be appointed to make this single decision. Sometimes you can have somebody appointed to sell the residence. Very, very specific. But an interested person can almost always petition to have someone appointed when the need is there. All right, so what if a bank won't take the power of attorney? Really, this does happen all the time. If the assets can't be easily moved to a more amenable institution, then a guardianship or a conservatorship may be necessary to gain access to the funds. Usually, the court will select the person you named as your agent. So even if ultimately doesn't work, for whatever reason this bank says, no, we're not going to take that power of attorney. How do we know it's legitimate? We can still go to court then and take that power of attorney and say, look, appoint this person. This is the individual's desires. So what happens if someone you select can't or won't serve? And I've talked about this. To protect against this, it's almost always a good idea to name alternative fiduciaries to serve if your first choice cannot serve. What I typically would say, 2, definitely. 3, even better. Because remember, if you don't have name alternatives, you end up in court. So what if your incapacity is only temporary? Well, after you're no longer incapacitated, you get your affairs back. Remember, the incapacity trustee only kicks in when you're incapacitated as defined in the trust. Okay? You can always allow them to continue to serve, but it's your choice. Can you change your mind? Yes, that's the beauty of it. As long as you have legal capacity, you can update the cast of characters as often as you wish. In fact, what we would typically recommend is, pulling it out and every couple years. In fact, often we will send emails to clients that we haven't heard from in a while and just say, hey, what's going on? Any changes? I'm very surprised at times when I get a response saying, yeah, there has been, or yes, let's meet, or this situation has changed. Now I need to do this. So the idea then is between your attorney, hopefully me, and your own desire, you will constantly be updating these documents to make sure that they reflect what you want at that particular moment. So again, the cast of characters, we have 3 sets. You're planning for you're alive and well. You're alive but incapacitated, and after you die. These cast of characters often will be the same individuals going through, but oftentimes there's a reason not to. That's why each estate plan is unique. The goal as you sit down and meet with me is to find out, hey, who in your family could serve in this, or who of your loved ones can serve in this capacity? Who do you want to take care of your kids? And we talk through it. And we come up with a solution and put it in writing so that you can have the peace of mind you deserve. If you are interested in following through with this, you can see down at the bottom of the screen there, I have a telephone number as well as an address. My telephone number is 951-246-2370. I'd love to hear from you and start this process of getting you taken care of for these 3 important phases of your life.